आज हम स्टार्ट करेंगे इंटेलेक्चुअल प्रॉपर्टी राइट। ठीक है, तो हम इसको 4 पार्ट में कवर करेंगे। ठीक है, तो पहला पार्ट स्टार्ट करते हैं। आईपीआर प्रोटेक्ट दैट यूज द इंफॉर्मेशन एंड आइडिया दैट्स आर ऑफ विच इज़ अ कॉमर्शियल वैल्यू। विच ऑफ द फॉलोइंग इज नॉट एन आईपीआर लॉ विच इज़ द एक्साइज एक्ट 1958। ठीक है, एज पर नेशनल इंटेलेक्चुअल प्रॉपर्टी राइट्स पॉलिसी पब्लिश्ड ऑन 12th May 2016, the objective 7 is which is a human capital development. ठीक है, World Intellectual Property Day is celebrated every year on which is 26th April. India recognized following as the intellectual property IP marks, which is the correct answer is the D, IP ना नी। ठीक है, नेक्स्ट क्वेश्चन देखते हैं। कंसिडर द इन्वेस्टमेंट इन द फॉलोइंग एसेट: ब्रांड रिकॉग्नाइजेशन, इन्वेंट्री, इंटेलेक्चुअल प्रॉपर्टी, मेलिंग लिस्ट ऑफ क्लाइंट। हाउ मेनी ऑफ द अबव कंसिडर intangible investment? Hence all are 3। ठीक है, नेक्स्ट क्वेश्चन देखते हैं। Accessibility legislation is intended to which is the improve access to service and disabled people in both the physical and virtual worlds. IPR protect the use of information and idea that are of which is a commercial value. In respect of which of the following item India does not have designation to specifically cover them as intellectual property: traditional knowledge, state art, publicity right, celebratory rights, computer program। Hence करेक्ट स्टूडेंट पूछा, hence 1 2 3 4 था करेक्ट। ठीक है, द Competition Act is not applicable to which of the following, which is the agreement related to IPR. Dash means the recognition of phenomena, properties or laws of the material which is scientific discovery. Which of the following is not a intellectual property, which is the goodwill. Dash is defined as the appreciation of the knowledge and genetic resource of farming and indigenous communities of individual or institutions seeking exclusive monopoly control over these resources and knowledge, which is the correct answer is biopiracy. Which of the following are the silent feature of the Patent Act 1970? It is a quantifies invention which are not patentable. It's provide for endorsement of patent with the word license of right. It provides the revocations of patents in public interest. It has a provision for validity periods also for the patent. Hence 1, 3 and 4 only. IPR protects the use of information and ideas that are of which is a commercial value. Information used in the business generally unknown to the public that the company has taken a strong measure to keep confidential is called which is a trade secret. In which article is intellectual property rights outlined, which is article 27. Which of the following is not intellectual property law, which is the Custom Act 1962. The authorization of the breeder is required for the selling of seed, a protected variety of which is the both farmer and researcher. Researcher can any of the registered variety act under the act for conducting experiment or research. These include the use of variety as the initial source of variety for the purpose of developing another variety, but repeats use which is the need for prior permission of the registered breeder. The following intellectual property are predictable in the software related to the computer program: trademark, patent, copyright, design. Hence only 2 and 3rd, patent and copyright. Which work process maximum number of patents in the world, which is the China patent in the world. ठीक है, what is the tried date, which is the it is a date on which the first application is filled. The next step after filling an international application is which is a national phase. Application are to be filled individually in the chosen country from the list of signed country. An international application can be withdrawn which is not later than 15 days before date of publication. The international filing fees is for benefits of which is for international bureau. When a work is said to be in public domain, it can be said that which is you can obtain a copy for free download from the internet. After the economics right have been transferred, which right remain with the author, which is the moral rights. What is a PBR, which is the plant breeder's right? By what name is PBR also known as, which is the plant varieties right? PBR gives exclusive control to the plant breeder over which one of the following material is the seeding, cutting, harvested productions, all of the above. What should be qualification of the rights to be exclusive, which is the a variety must be new, a variety must be distinct, a variety must have uniformity, hence all of the above. When will be the variety new, which is the no commercialization for more than 1 year in the country of origin. How for how many years is an exclusive right given for a plant variety, which is 20 to 25 year? Which one is the criterion for the registration of the new variety, which is a distinguishness? What type of rights is IPR under PPB FR Act 2001, which is a dual right? What is a dual right under PPB and FR Act 2001, which is a one is the for the variety and other is for the breeder? What is the EDV, which is the essentially derived varieties? Period for protection under Section 5 of the Seed Act 1956, field crop 15 year, trees and vines 18 year, and the notified varieties 15 year. Hence, all are the true. What is the seed overseeability? Hence, the right to the breed and exchange diverse open source seed. Which of the following act in relation to the semiconductor integrated circuit layout design does not amount to commercial exploration, and lean on semiconductor integrated circuit? For the purpose of Semiconductor Integrated Circuit Layout Design Act 2000, the central government may appoint a person as, which is the correct answer is the Register of Semiconductor Integrated Circuit Layout Design. नेक्स्ट क्वेश्चन देखते हैं. इंटेलेक्चुअल प्रॉपर्टी राइट इज विच इज द नेचुरल राइट, एक्सक्लूसिव राइट, प्रॉपर्टी राइट, हेंस ऑल ऑफ द अबव. ट्रेड रिलेटेड एस्पेक्ट ऑफ इंटेलेक्चुअल property right agreement 1994 exclude, which is the article 6 by of the Berne Convention 1883. Berne Convention 1886 is administered by which is the World Intellectual Property Organization. Intellectual property means which is the creation of mind in corporeal property, hence A and B is correct. WPPT is acronym for which is the WIP, performance and program treaty. Intellectual property rights can transacted by means of which is a scale assignment license, and all of the above. Starbogus Convention 1971 deals with is for international patient classification. The Hague Treaty deals with which is the international registration of design. The Rome Convention deals which is for related rights, enabling rights, hence both A and B. Budapest Treaty 1977 deal with which is the international recognition of deposits of microorganism for the purpose of patent procedure. Budapest Treaty 1977 is administered by which is by World Intellectual Property Organization. Madrid Agreement related to international registration of trademark. Intellectual property right is which is for exclusive right. Intellectual property right which is for provides return of investment, protect labor of creation, protect utility of creation, and so all of the above. Intellectual property include which is include invention and industrial design, both and be. Perspective theory of patient is given by which is given Eden Kitchen. Collaborative research agreement can be used for which is used for technology transfer, technology licensing in both A and B. MTA deals with the transfer of which is a tangible material. Patient rights can be licensed by which is for exclusive license agreement, non-exclusive license agreement, solo license agreement, hence all of the above. Non-disclosure agreement can be used for transfer of technology. Yes. IP auditing is done to find which is done to find potential IP, potential inventor, and author to register the IP, hence all of the above. Intellectual property right promises which is resource allocation following the dash to the multilateral negotiation under the General Agreement on the Tariff and Trade Agreement on the Trade Related Aspect of Intellectual Property Right TRIPS are arrived at, which is arrived by Orgiri round. Intellectual property is limited period exclusive right. Intellectual property of product, which is the investment, skill level, and judgment, creativity, and all of the above. Prospect theories proposed theories applicable to both intellectual property and public goods. Trade related aspect of intellectual property trade rights agreement 1994 is administered by which is a World Trade Organization. India became a member of the Cooperation Treaty on 7 December 1998. The purveyor of labor theory of intellectual property is J. Locke. Some things having use utility is required to be protected in start in which is the utility theory. The economic justification behind intellectual property is to protect investment to provide return on investment. Intellectual property cannot be touched, felt, and measured, hence all of the above. Ruler natural desert theory can be made applicable to which is the A and B intellectual property right, copyright. WIPO is acronym for which is World Intellectual Property Organization. One of the proposer of utility theory is which is a Bentham. Root of labor should be rewarded start in which is labor theory. The proposer personality theory is which for Hegel. Intellectual property right is which for economic right, moral right, property right. Intellectual property right is based on the iteration theory, non-iteration theory, and both in. License of IP rights means which is for more permission to use IP rights. Assignment of IP rights means which is complete transfer of IP rights. The option ठीक है. IP due to diligence is done to which is both correct the title of IP, correct the form of IP. IP valuation can be done by which is a cost-based method, income-based method. WTA is an acronym for which is for World Trade Organization. International classification of goods and services for the purpose of registration of mark is which is for NIC classification. Paris Convention for the protection of the industrial property 1883 stipulated that the right to priority for filing a patent application in member country is for 12 months. Non-utilization theory is based on which is based on moral right and economic right. Exclusive license is relation to invention referred to which is referred to a license which prohibits even the licensor to make use of licensed invention. Non-exclusive license is relation to the copyrighted work referred to which is a license which only allows the license to use the copyrighted work and does not prohibit the licensor to further license the copyright work. The grant back licensing referred to licensing in which the license grant the license back to the licensor on the improved license invention. The international recognition of the deposit of the microorganism for the purpose of patent procedure is governed by which is Budapest Treaty. Compulsory licensing denote which is for sanitary licensing and non-voluntary licensing. One of the features of the following agreement in Central Attack, which is the Madrid Agreement, Paris Convention for the Protection of the Industrial Property 1883 stipulates that the right to priority for filing a trademark application in a member country is for 6 months. As per the Tribunal Reforms Act 2021, the Intellectual Property Appellate Board was dissolved, which is false. Which High Court was the first High Court to come out the Intellectual Property Division rule after the abolishment of Intellectual Property Appellate Board, which is the Delhi High Court. It is possible to assign intellectual property rights without transfer to the title, hence true. Trade sectors are protected in India under which law, which is a Contract Act 1872. Agreement under the Contract Act 1872 for restraint of trade are which is a void. Intellectual property law promote competition and non-anti-competitive practice, which is true. Is India party to Patent Law Treaty 2000, which is a yes. The Lisbon Agreement deal with the protection of which intellectual property appellations of origin. Is India a contracting party to Marrakesh Treaty? Yes. Which treaty aimed to standardize the patent filing process with respect to national and regional patent application, hence Patent Law Treaty. What is the name of the treaty administered by WIPO, which has the humanitarian dimension and is for benefit of the blind, visually impaired, or otherwise print disabled, hence Marrakesh Treaty. Has India signed the Nairobi Treaty on the Protection of Olympic Symbol is 1981. Yes. Which treaty deals with protection of work and rights of the author in the digital environment? WIPO Copyright Treaty. Which treaty deals with right of performers in audiovisual performance? Which is the Beijing Treaty. Which WIPO administrated treaty protects the performer and producer of phonogram in the digital environment? The WIPO Performance and Phonogram Treaty. Which convention is jointly administered by WIPO, International Labour Organization, and the United Nations Educational, Scientific and Cultural Organization UNESCO, hence Phonogram Convention. As per Section 2K, Protection of Plants, Varieties and Farmer Right Act 2001, farmer means any person who cultivates crop by cultivating the land himself, cultivated crop directly supervising the cultivation of land through any other person, convert the preserve severally or jointly with any other person, any wild species or traditional varieties through selection and identification of their useful properties, hence all of the above. An extant variety can be registered under Protection of Plants, Varieties and Farmers Right Act 2001. It is distinctive and uniform and stable, and essentially derived variety is protected for 6 to 9 years. Compulsory licensing can be granted for 3 years after registration. Opposition of registration of plant variety can be filed only in the ground that uh, the person opposing the application is entitled to the bidder right. The variety is not registrable under the Act. The grant of certificate of registration may not be public interest, and the variety may have the adverse effect on the environment and all of the above. Okay, next question. The farmer variety means which is the variety which is wild, relative or land race of the variety about which of the farmer possesses common knowledge. Variety traditional cultivated by farmer, hence is correct. Seed means which is a type of living embryo. Flat variety can be registered by which is the Indian national and national from conventional country, hence is correct answer. नेक्स्ट क्वेश्चन देखते हैं द सूट फॉर infringement of registered variety under the act can be instituted at that which is the district court. Breeders are enlightened to which is the save, saw and resaw, hence all of the above. The central government is obliged under the Protection of Plant Varieties and the Farmer Right Act to constitute which is the National Gene Fund. Compulsory license can be granted to prevent monopoly under the Protection of Plant Varieties and Farmer Rights Act, which is yes, as per Section 2ZA, 2A, I think, Protection of Plant Varieties and Farmer Right Act 2001, a variety means a plant grouping except microorganism within a single botanical taxon of the lowest known rank, which can be which is the all of the above. मतलब defined by the expression of the characteristic regulating form a given genotype of that plant grouping distinguished from any other plant grouping by expression of the least one of the set characteristic considered as the unit with regard to its stability of game propagate which remain unchanged after such propagation. Researcher rights include which is the free access to protected material, complete access to protected material. Next question, the The Protection of Plant Varieties of Farmer Right Act 2001 has provision like which is the benefit sharing, compulsory licensing. Denomination given to plant varieties under the Protection Plant Varieties and Farmers Act 2001 can be registered as a trademark henceforth. As per Section 2(1) Protection of Plant Varieties and Farmer Right Act 2001, an essentially derived variety in respect of an initial variety means which is predominantly derived from such initial variety. It is clearly differentiable from such initial variety, conform to such initial variety to the expression of essential characteristics, hence all of the above. In order to register plant variety, it should be which is the all of the above, new and uniform and distinct. The objective of the Protection of the Plant Varieties and Farmer Act 2001 is which is the protection of right of farmer, protection of right of breeders. As per as the Section 2(j) Protection of Plants, Varieties and Farmer Right Act 2001 can extend variety means which is the a variety available in India which is notified under Section 5 Seed Act 1966, farmer variety of common variety, any other variety that public knows, hence all of the above. ठीक है, अब नेक्स्ट क्वेश्चन देखते हैं. DUS is acronym for which is a distinct, uniform, stable. DUS criteria has been laid to a request for protection of which is a plant variety. Extinct variety is protected for which is protected 15 years from the date of notification of that variety of the central government under Section 5 Seeds Act 1966. Variety include which is a new variety, extinct variety, farmers variety. Breeder means which is for any farmer, groups of farmers, any person who had breed or developed a variety, and all of the above. Trees and vines under the Protection of Plants, Varieties and Farmers Right Act 2001 are protected for 18 years. As per the Protection of Plant Varieties and Farmer Act 2001, breeders include which farmer, group of farmer, institution, and all of the above. Essential characteristic means heritable trait of plant variety which are determined by expression of one or more genes. A right of breeders include which is for protection, selling, and distribution, hence all of the above. The Protection of Plant Varieties and Farmers Right Act 2001 provide for researcher right, breeders right, community rights. Article dash of the trade related aspect of intellectual property rights agreement to the is the source of the Protection of Plant Varieties and Farmer Right Act 2001, which is 27. India passed the Protection of Indian Varieties and Farmer Right Act 2001 for drawing its mandate from which is Article 27(3) of trade related aspect of intellectual property right agreement. Patent Act. Which of the following are the silent features of the Patent Act 1970? It is a codifies invention which are patentable. It provides an endorsement of patent with the word license of right. It provides the revocation of patent in the public interest. It has a provision for validity period also for patents and 1, 2, 3, 4 all statements. According to Section 6 of Patent Act, an application of a patent for invention may be made by true and first inventor, a sign of true and first inventor, legal representative of true and first inventor, owner of copyright work. Hence, ABC is correct. And the innovation for being patentable has not been justified the following extraordinary. Which of the following is our non-patentable invention? For various invention, more discovery of scientific principle, mathematical method, literary or artistic method, hence ABCD is correct. Which of the following is correct about the Parent Bill 1953 and Patent Bill 1965, which is lapsed due to political reason? Select the invention that are not patentable in the India method of agriculture or horticulture, invention whose claims are contrary to the well-established natural laws, a presentation of information and topography of integrated circuit, invention related to atomic energy, and invention judicial to the interest of security of India. Hence, ABCD and all statements are correct. Which section of Patent Act 1970 empowered the central government to revoke patent patent in public interest, which is section 66. The Patent Amendment Act 2002 comes into from which date, which is the 20th May 2003. Mr. Milky discovered a totally new way to process milk. Cheese made from it. It do not have the any fat identify the applicable category IPR is a patent. In order to get convection status, an applicant should file the application in the Indian Patent Office within days from the date of first filing similar application in the convection country, which is 12 months. What is the name of the Act of 1856 on protection invention based on the British Patent Law 1852, in which certain exclusive privilege grant to inventor of the new manufactures of period of 14 years. Hence, which is the correct answer is the Act 6 1856. Which of the following are the silent feature of the Patent Act 1970? But it is a codify invention which are not patentable. It provides for endorsement of patent with the word license of right. It provides for revocation of patent in public interest. It has a provision for validity period also for the patent. Hence, all the statement is correct. Which provision for Patent Act state that discovery of any living thing or non-living thing substance occurring in nature is not patentable? Hence, Section 3C. Bayer Corporation versus Union of India 2011 case is dealing on which subject matter, which is the working of patenting process. Which of the following is incorrect? Is the invention shall be published before applying for patent. Moral right is concept prevailing in which is the copyrights. Arrange the correct sequence in which an application for grant of patent will be considered. Opposition under section 25(2) of the Patent Act 1970. Publication of application, filing of claims, request for examination, grant of patent. Hence, DBCEA is the correct option. Chronological arrange the following in the order for the chapter number sequence provided under the Patent Act 1970. Application for patent, amendment of application and specification, publication and examination of application, theory by grant of patent and rights confirm, opposition proceeding to grant the of patent in A, C, E, D, and B. Which provision of Patent Act 1977 allow third parties to lodge pre-grant opposition by way to written objection of observation regarding the patentability of the invention? Hence, Section 32. Which of the following is not an objective of grant of patent? Which is the patent confirm permanent monopolistic exclusive market right to the inventor in the order to recoup the cost of investment in R&D, recap profit. Which provision of the Patent Act 1970 reflect the philosophy of patenting and working of patent invention, which is Section 83. Which provision of the Patent Act 1970 deals with the content of specification, Section 10? Which of the following statement is true about the patent application? Correct option is the an patent can seek patent protection of an invention simultaneously in many countries by filing a single international patent application under a PCT instead of filing several separate national or regional patent application, and the patent is granted by the WIPO for all the convection countries of PCT. Which provision of the Patent Act 1970 deals with grant of certificate of patent? And Section 43. Indian Patent Office are located in which is Kolkata, Mumbai, Delhi, and Chennai. The term of patent in case of international application filed under the Patent Cooperation Treaty designated India shall be dashed from the international filing date accorded under the Patent Cooperation Treaty, which is 20 years. Which of the following is not a correct grant of the patent under Patent Act 1970? Correct answer is D. Right to issue duplicate patent. Which provision of the Patent Act 1970 provision right to co-owner of patent, which is Section 50? Which of the following is a ground for grant of compulsory license on patent under Section 80 Patent Act 1970? Hence, reasonable requirement of the public with respect to patent invention have been satisfied? Which country had grant patent on use of turmeric in wound healing in 1995? United States of America. What is the name of long grain aromatic rice grown in India and Pakistan for which earlier patent claims are filed by US rice was made by firm and registration of the trademark Taxmati in UK, which is a basmati rice. Which of the following is a not type of patent, which is a copyright? Which of the following is the ground of the revocation of patent, which is the that the patent has obtained wrongfully in the conviction of the rights of the petitioner or the any person under the through whom he claims that the invention so far as claimed in any claim of the complete specification was claimed invalid claim or earlier property priority date contained in the complete specific other patent grant in India that the invention so that claim in any claim complete specific and not useful, hence all of the above is correct. Which section of the Patent Act 1970 deals with person entitled to apply the patent, and section 6 Patent Act 1970, section 7 of Patent Act 1970 deals with which form of application? Which section of Patent Act 1970 deals with invention relating to atomic energy not patentable, hence section 4 Patent Act 1970, section 15 of the Patent Act 1970 deals with power of the controller to refuse or require amendment application etc. in certain case. What is the subject matter of patent, which is invention? Why an invention should be patented? It gives protection to the patentable invention. It gives legal recognition the invention. It makes upper aware of the fact as the whom does the invention belong. Patenting once the invention makes the useful data relating not to invention available to the invention for the further research and development. Hence, all of the right of the patentants are, which is all of the above. A policy or behind the parent system is, which is the to benefits, none of the above. Okay. Statement: the Patent Corporation PCT assist application in seeking patent protection internationally for their invention. PCT help patent offices with their patent granting decision, and PCT facilitate public access to wealth of the technical information related to those inventions. Hence, all are the correct. An option may be requested soon before the grant of patent pre-graded option or after the grant of patent post-graded options. Hence, both statement 1 and 2 are correct. The internationally accepted term of patent is, which is the 20-year. Patent are granted for new, which is both for new product and new process. The term of patent in India is 20 years from the earliest priority date. And thank you for watching this video. Next part 2 में हम आगे का कवर करेंगे. ठीक.